It's 5:06 on Wednesday, April the 14th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck. Here. Curcio.
Here.
Farmer.
Here.
Griffey.
Here.
Hardaway.
Here.
Howell. Lamberth. Moody.
Here.
Russell.
Here.
Sexton.
Here.
Chairman Doggett.
Present.
Mr. Chairman, you have a quorum.
Thank you, ma'am. Before we begin, any personal orders from the members? I actually have one. In our presence today is a great orator, storyteller, and my district attorney general, General Brent Cooper. Welcome. Yes, sir. Go ahead.
Hey, I want to thank you for. I wanted to let you recognize our our DA since you're chairing this committee, but be remiss if I didn't mention he's my DA too. So welcome,
Representative Russell.
Thank you, Mr. Chairman. And my district attorney is here too, Mr. Steve Crump.
Anyone else? Representative Hardaway.
Thank you, Mr. Chairman. I don't see my district attorney.
All right. Well, we're going to go through the calendar. We have a few bills to dispose of here right out the gate. We'll go ahead and take care of those. Excuse me. Item number 5, House Bill 413 by Representative Lamar. We are going to roll that to the special calendar. Item number 6, House Bill 1159 by Representative Stewart is off notice. Item 7, House Bill 1160 by Representative Stewart is off notice. Item 8, House Bill 1316 by Representative Stewart is off notice. Item number 9, House Bill 1574 by Representative Stewart, rolled to the first calendar of 2022. And go back to item number 2, the one I missed there. House Bill 1385 by Chairman Todd is off notice. This brings us back to item number 1, House Bill 1 by Representative Hardaway. Sorry, we have a parliamentary procedure here. Go ahead.
Chairman, parliamentary inquiry. Excuse me. Mr. Chairman, parliamentary inquiry, the items that were taken off notice, specifically there were 3 of them, I think, by Representative Stewart. Are we past the deadline for those items to be back on the calendar this year? They've been on the calendar several times, and since they are off notice, is the intention then of the sponsor that he will not, by his own choice, be going forward this year with any of those ideas?
I don't know the intent, but the deadline is passed.
Thank you, Mr. Chairman. I just want to make sure, and if the deadline is passed, then I think the intent is obvious.
Thank you. Okay, Representative Hardaway, you have a motion and a second on House Bill 1. You may proceed.
Thank you, Mr. Chairman. And we have an amendment, number 36117.
You have a motion and a second on the amendment. You're recognized.
Thank you, Mr. Chairman. And since we want to be conscious of time and be respectful of everyone's time, I have a couple of witnesses that need to be heard. And I would ask that we go out of session for those witnesses to be heard, Mr. Chairman.
Okay, very good.
After we put the amendment on.
Okay. Question's been called on the amendment. Any objection? Seeing none, we're now voting on adding amendment number 6117 on the House Bill 1. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We adopt. We are now on House Bill 1 as amended. Representative, do you wish to go out of session at this time to hear from your witnesses?
Yes, sir.
Okay.
The first one would be Professor Daniel Keel, who's a law professor from the University of Memphis.
Okay, thank you very much. Without objection, we're going out of session. Mr. Professor Keel, if you would, there is a If you use that podium right there, there's a button, looks like someone talking there. If you'll push that, turns your microphone on, introduce yourself, state your name for the record, who you're with, and then you'll have 4 minutes of testimony.
Is it on? We're good? Good evening. My name is Daniel Keel. I'm a FedEx Professor of Law at the Cecil C. Humphrey School of Law at the University of Memphis, also an Associate Director at the Benjamin Hooks Institute for Social Change, also at the university. I teach constitutional law. In that work, I have done some writing and research on the application of the death penalty to individuals with intellectual disability, and so that is the topic that I'm speaking on this afternoon. Tennessee has been ahead of the curve in the treatment of individuals with intellectual disability historically when it comes to the death penalty. In 1990, the Tennessee legislature was among the first in the nation to prohibit the sentencing of individuals with intellectual disability to death. Many states have followed, and thus since 1990 it has been unlawful under our state statutes to sentence an individual with intellectual disability to the death penalty. In 2001, the Tennessee Supreme Court went ahead of the United States Supreme Court in declaring that the execution of individuals with intellectual disability violated the state constitution. A similar decision occurred from the federal Supreme Court under the federal Constitution's 8th Amendment in 2002, a year later. So again, Tennessee was ahead of the curve on that. And thus, execution of individuals with intellectual disability has also been unlawful and unconstitutional in our state, at least since 2001. In 2011, Tennessee Supreme Court, again ahead of the federal Supreme Court in determining that the type of evidence available to prove intellectual disability must be broader than what had previously been utilized. So that has been the case since 2011 here in Tennessee. However, despite all of this history of being ahead of the curve, the state has a gap in its intellectual disability law with regard to the death penalty. Because of the timeline of the changes in when someone could be sentenced, someone with an intellectual disability could be sentenced, and what evidence would be available to prove intellectual disability, there are some individuals on death row here in our state who have credible claims of intellectual disability that have never been heard. As a result, there is a risk that the state could execute someone that has an intellectual disability. There's no question that such an execution would violate both the state and federal constitutions. While the Supreme Court has recognized this problem, the Tennessee Supreme Court has recognized this problem, it has not been able to settle on a solution. In a 2016 case that rejected a request by an individual for a hearing on whether or not he had intellectual disabilities and thus was ineligible for the death penalty, this Tennessee Supreme Court noted, "We encourage the General Assembly to consider whether another appropriate procedure should be enacted to enable defendants condemned to death prior to the 1990 enactment of the Intellectual Disability Statute to seek a determination of their eligibility to be executed." The statute being considered answers that call, helps ensure that those with credible claims of intellectual disability have an opportunity to present their evidence before it is too late. This bill helps ensure that our state will continue to operate within the bounds of the Constitution when it comes to treating individuals with intellectual disabilities to their constitutional rights as applied with regard to the death penalty. Thank you.
Thank you very much. First on our list is Leader Lamberth.
Thank you, and thank you, sir, for being here today. We appreciate it. Since you're a professor, obviously you help guide kind of young minds on how they think about these issues, and to better help us understand kind of your testimony today and how it could be taken, I mean, do you support or oppose the death penalty, just kind of in general? I'm trying to understand kind of what frame of reference the testimony comes from.
Well, I think the testimony comes from what is constitutional and not constitutional under the state and federal constitutions with regard to the death penalty. I have never been in a position to either impose or not impose the death penalty. I guess I would tend to be someone who is skeptical of the use of the death penalty, but whether or not, regardless of that, I think that the constitutionality is unquestioned.
So fair enough to say then anything that makes it more difficult for the death penalty to be actually implemented would be something that would be better to put in our laws, in your opinion? Put as many obstacles, so to speak, so that we ensure that every single avenue is exercised before that potential penalty, which is obviously the final penalty that could be utilized, would be carried out.
I don't know that I would use the word obstacles, but I do think that we should do everything in our power under our laws to ensure that if we are going to implement the death penalty, that we do so in a constitutional way.
Thank you, sir.
Thank you, Representative Beck.
Tell me how this bill will remedy any constitutional confusion as to whether Tennessee's following our Constitution and the U.S. Constitution, please.
Sure. There is, it is unconstitutional under our state constitution since 2001 and unconstitutional under the federal constitution since 2002 to move forward with execution of an individual with intellectual disabilities. There are some individuals on death row in Tennessee who have credible claims that they would qualify as individuals with intellectual disability. The execution of those individuals, should they have intellectual disability, would be unconstitutional. Thus far, there hasn't been an opportunity for these pre-1990 sentenced individuals to provide evidence of intellectual disability. This would provide the opportunity to do so. It would provide the court with an opportunity to determine whether or not individuals have intellectual disability and therefore would be eligible or ineligible for the death penalty. So an execution of an individual with intellectual disability, which is plausible under our current law, would be unconstitutional. This helps ensure that that doesn't happen.
How many people are we talking about on death row right now in Tennessee that would have possibly fall under this?
I do not know the number specifically. I know there is at least one.
Very good. Thank you so much.
Thank you, Representative Sexton.
Thank you, Mr. Chairman. When you answered a question a moment ago, you said whatever is constitutional. What is constitutional according to the death penalty? What does the Constitution say about the death penalty?
It says a lot of things about the death penalty with regard to individuals with intellectual disability. Is that the question?
Not really. Just want to know what the Constitution says about the death penalty. You've used the term Constitution several times, and I'd like to know what part of the Constitution that you're talking about when you're talking about the death penalty, because I don't really think the Constitution addresses, per se, the death penalty.
Yes, the 8th Amendment to the Constitution, which has a prohibition on cruel and unusual punishment. I believe it's Article 1, Section 16 of our state constitution also has a prohibition on cruel and unusual punishment, and that is where the death penalty jurisprudence lies. Wouldn't
that be your definition of it? Because cruel and unusual punishment doesn't have to be death penalty. As a matter of fact, the death penalty could be imposed because that it was just and right. So it wouldn't be considered cruel and unusual punishment. So again, where do you find the death penalty in the Constitution? I don't think that you can use the Constitution without coming up with the actual wording in the Constitution.
Well, the Tennessee Supreme Court has found that the implementation of the death penalty violates Article 1 and Section 16 of the Tennessee Constitution's prohibition on cruel and unusual punishment. Our Tennessee Supreme Court is the interpreter of the Tennessee Constitution, and that is what they have found. Similar finding with regard to the 8th Amendment of the federal Constitution with regard to individuals with intellectual disability and cruel and unusual punishment.
In your study of law, have you ever known for a Supreme Court ruling to be overturned?
Yes.
So the Supreme Court is not the Constitution. It's just an opinion of that court. And they may rule on it, and that rule may stand until another jurisprudence comes along or court comes along and changes it. So again, you're not finding the death penalty in the Constitution. So my statement is this: don't use something that's not there and try to make it appear like that you're using the Constitution and it's unconstitutional. You can't find something unconstitutional that's not in the Constitution to begin with. And so the wording, it's kind of like the separation of church and state. It's not in the Constitution, it's not in our founding documents, but it's used very liberally and makes people think that it's part of our founding documents when it's not. So that's my point. Don't be using the Constitution along with the death penalty because it's not in there. And that's my point. Thank you.
Thank you. Representative Griffey.
Thank you very much, Mr. Chairman, and thank you, Professor Keel, for being here. You indicated that you know of one person on death row that this legislation would impact. Is that Purvis Payne?
That is the person I'm aware of, yes.
Okay. And you mentioned about the Supreme Court in, I believe it's Purvis Payne's appeal. I can't remember if it was his direct or post-conviction appeal. I believe it was a post-conviction matter. In 2016, invited the legislature to address, or legislatively how to address these situations where you have someone that has potentially intellectual disabilities. If I recall, and I read the case just a couple of days ago, I think the Supreme Court also said that didn't Purvis Payne waive or forfeit his ability to challenge his the claim that he was intellectually disabled? I think it's in the sense of Van Tru's decision or Van Tran decision. Is that what you recall from the opinion as well?
So I guess I would first note, though Purvis Payne would be someone who would be eligible under this statute, the statute would be generally applicable for anyone for whom the intellectual disability issue might have not been litigated previously, or no finding on that topic previously. So with regard to the Payne case in particular, I think that what I recall is that the definition of intellectual disability that existed at the time, which has since been found to be violative by the Tennessee Supreme Court of the Constitution, would not have made him eligible to bring that appeal at that time. And that was something that the Tennessee Supreme Court recognized as well, was that due to the timeline in which interpretation of the law with regard to intellectual disability changed, it would not have been something that he would have brought in 2001 or 2002, for example.
Well, it was my understanding that the court specifically addressed that and said that he could have right after the Van Tran's opinion, and he failed to do so. And in fact, it was after the subsequent decision after the Van Tran. I can't remember the case name on that. But what I'm concerned about here is, and if I also recall in Mr. Payne's appeal in the 2016 Supreme Court decision, he had an expert came in and said, well, he had probably an IQ score of under 70 on one of his tests, but then in subsequent years it was a 72 and maybe a 74 or something like that. Then the experts get into the adjustments of intelligent quotients, how they progress over time, and the expert adjusted for a 0.3 or 0.4 for that. And they also indicated that even under that standard, he probably wouldn't meet the Tennessee statute of 70 or below. So what this legislation is essentially going to do is going to allow Mr. Payne to have a second bite at the apple. Would you agree with that assessment or not?
I don't think that I can't say for certain what the Tennessee Supreme Court said with regard to that, but I do know that there hasn't been an evidentiary hearing whatsoever on that. The point that I believe was being pursued was to try to get a finding with regard to intellectual disability, and that did not happen.
And thank you. And for clarity, so everyone understands, Mr. Payne and his attorneys had a chance to raise his intellectual disability at trial level, post direct appeal, Supreme Court, post-conviction, and then federal habeas. And I think it wasn't until after his federal habeas, he came back to Supreme Court on this additional motion for the intellectual disabilities. Does that fairly summarize your recollection of how his case proceeded through the the justice process?
I believe that he raised the intellectual disability claim after the Tennessee Supreme Court in 2011 amended how intellectual disability is interpreted. So I think there was a one-year period after that, and I believe that's when he raised the intellectual disability claim because of the adjusted definition. That's my understanding. I'm not representing him, so I don't know.
And look, I thank you, and part of the reason I bring these things up is these cases are extremely complicated and tedious, and they get down in the legal weeds, and but I think it's fair to say that there's are folks that are opposed fundamentally to the death penalty, and they are well-funded, and they try to help these individuals that are sentenced to the death penalty, and the victims, they generally don't have someone in their corner advocating for the death penalty. They move on with their lives and have to just sit back and watch the consequences. And I just hope we all remember the victims when we consider amending state statutes to giving people additional chances at the apple. So thank you for coming. Appreciate you, and nice talking with you. Look forward to meeting you again too. Thank you.
Thank you, Representative Griffey. Next on the list, Representative Leader Lamberth.
I failed to mention earlier, by the way, you don't know who I'm talking about, it doesn't matter, but some of your former students have actually bragged on you to me. So just so you know that I didn't realize this dude stepped up to the microphone, but I know you only by reputation. Like I said, we've not met before, but some of your former students have bragged about you and spoken very glowing terms on your performance as a professor, and that they learned a lot from you. So I appreciate your work there. I think I may have misheard this earlier, but when you stated earlier that Tennessee Supreme Court had found that the death penalty was unconstitutional, I think you meant within the context of this conversation.
Correct.
Yes,
Correct.
I mean,
With
not
regard
overall,
to-
obviously, because
Correct.
there are new dates that are set for prisoners that have been, found guilty, and that penalty has been declared by a jury. So that wasn't a broad statement. That meant within this context.
Correct.
Just want to make sure.
Yeah, I apologize if I misspoke. It was with regard to execution of individuals with intellectual disability.
Perfect. Thank you, Professor. Appreciate it.
Any other questions for our guest? All right. Representative Hardaway.
Thank you, Mr. Chairman, and thank you, Professor, for being here. I'd like to explore a couple of things. On the state of being intellectually disabled, it's not merely the nature of the disability itself, but there's also a question of whether an individual who is intellectually disabled can provide adequate assistance to the legal counsel to defend him or herself.
Yes, the justification for the finding in 2001 in the Tennessee Supreme Court and in 2002 in the federal Supreme Court was that individuals with intellectual disabilities are not able to participate in their defense to the same extent as they might otherwise. In addition, there is questions about culpability with regard to individuals with intellectual disability, and the thought that the imposition of the death penalty would not serve its penological purposes for such individuals.
And if we're looking, Mr. Chairman, if we're looking at the schedule, the calendar of the decisions from the courts, and we're looking at the ability for the legal counsel for Mr. Payne to raise the question, go back through that again on when he could have or should have compared to the different rulings.
So I would note again that the statute would be generally applicable not only to one individual, but with regard to Mr. Payne's case, my understanding is that the sentence occurred prior to the prohibition on sentencing individuals with intellectual disabilities, which came in 1990. In 2001 was when when the law changed so that not only sentencing but also execution of individuals with intellectual disabilities violated the Tennessee Constitution according to the Tennessee Supreme Court. At that time, the definition of what constituted intellectual disability was fairly rigid and included circumstances such that any test in which an individual's IQ was deemed over 70 would make someone ineligible to be found to have intellectual disability. So I believe in Mr. Payne's case there had been such at least one test in 2001 when the Van Tran case changed the law here. It was not until 2011, I believe it's the Coleman case, when the Tennessee Supreme Court adjusted what must be considered evidentiarily in terms of proving intellectual disability so that the 70 would not sort of per se make someone ineligible to be considered with intellectual disability. And so it was at that time, after that evidentiary change, that I believe Mr. Payne brought his claim that he was ineligible for execution due to intellectual disability.
And would it be fair to say that quite frequently, whether we're talking DNA or fingerprints or whatever, there are periods where there's a lag time, where the law actually has to catch up with science and catch up with advances in psychological medicine?
Yes, and I think that this legislature has recognized that in changing the definition of intellectual disability in other parts of the code as well. In addition, I know that after the 2002 federal Supreme Court case with regard to intellectual disability, approximately 7% of individuals on death row brought claims, and a significant number brought claims claiming that they were ineligible for execution due to intellectual disability, and a significant number, maybe as many as 40% of those 7%, were deemed to be intellectually disabled and therefore ineligible for the death penalty. Those were people who would have, if their executions gone forward, been unconstitutionally put to death. The ability to challenge that was what prevented those executions from going forward.
Is there anything that I should have asked that I haven't asked you?
I don't think so.
Thank you, sir. Thank you, Mr. Chairman. Thank you, sir, for being here. Mr. Chairman, I'll note that he's made that 200-mile drive on more than one occasion, and we really appreciate his dedication to the pursuit of justice.
Thank you all.
Yes, sir. Thank you for being here with us. Next on our list, Ms. Kelly Henry. A familiar face. If you remember the procedure, if you will, introduce yourself and who you're with, and you'll have 4 minutes for your testimony.
Thank you so much, Chairman. My name is Kelly Henry, and I am here as an attorney and member of the bar, but as it happens, Representative Griffey, I actually am Purvis Payne's lawyer, so I can answer many of those questions for you as well, and clear up some misconceptions that you actually have about the procedural history of his case, because I think it is important. Since my testimony here last, I was asked by Representative Hardaway to do some additional research on the issue of intellectual disability and the death penalty. Specifically, he asked me to look at the interrelationship between race and intellectual disability claims and the death penalty. And I am embarrassed to say that even though I do live in these legal weeds every day, I did not know that 80% of the people with intellectual disability claims are people of color. That's an astoundingly high rate. And so we already know from studies about the death penalty that race does play a role. And I'm not saying intentionally, I'm just saying we know it's a fact. The studies show it. So folks with intellectual disability who are people of color, the deck is doubly stacked against them. And we also know that 25% of the people who have been exonerated, found innocent, were people with intellectual disability. So when the U.S. Supreme Court decided that it was unconstitutional to execute, or that it violated the Eighth Amendment's prohibition against cruel and unusual punishment, to speak more specifically, to execute people with intellectual disability. That was one of the concerns, is that people would be wrongfully convicted just because of their intellectual limitations. And we're talking about something here that is not waivable. So in 2016, when the court looked at the Payne case, they did not find that Mr. Payne waived his claim. And in fact, they said in that case and in also the Keene case that the state of Tennessee has no interest in the execution of people with intellectual disability, because this is not a procedural issue, it's a substantive issue. So what I would draw your analogy to would be a case that came out a few years after Atkins, which is the Roper versus Simmons case. It's an easier analogy because it deals with not executing children. So if somebody was convicted and sentenced to death and their birth certificate wrongfully said that they were 18 years old and 1 day, they could be sentenced to death. And if they got up to their execution date and somebody went back in the records and found out, no, they were actually 17 years old, you couldn't execute them. Period, paragraph, the end. You can't waive that substantive claim. And that's really what the court was saying in the Payne case, which was why they were saying that this body should take up the cause. And you should be applauded for doing that, as the former Solicitor General of the United States, Ken Starr, told you in his testimony to this body when he supported this claim, as did the American Bar Association, who told you that this legislation needed to happen, as did the person who wrote our statute in 1990. Now, Mr. Payne could not file an intellectual disability claim under the statute because the 1990 statute was not retroactive. The court specifically found that. Mr. Payne was convicted in 1988. So that prohibition did not exist at the time of his conviction. He was not allowed to raise the claim in post-conviction either, nor was he able to raise the claim in habeas. And in fact, at the time that Atkins was decided, he had been granted habeas relief in federal court. At the time Atkins was decided, he wasn't actually under a capital sentence. It wasn't until 2005 that the Sixth Circuit reversed that decision granting relief based on another decision out of the U.S. Supreme Court. So Mr. Payne could not raise his claim until Tennessee law was interpreted in a way to meet the constitutional standards. But even so, the Coleman decision doesn't meet what the court requires in Moore and Hall. And so what I would finally say to you is that regardless of your policy concerns, I'm aware of cases that are moving down the pike. I can guarantee you that if you don't pass this bill, there will be more litigation that will be more costly to the taxpayers and more costly to the victims, because there are cases that are going to get reversed that I'm aware of in the pipeline that might not help my client, Mr. Payne, but this legislature doesn't pass legislation about a single client. This legislation will save time and money. Thank you.
Thank you very much. Any questions for our witness? Representative Hardaway.
Well, it's hard to believe. But thank you, ma'am, for being thorough. And the disparities that exist on death row with intellectual disabilities and in general in the prison system. Is there disparities with those who are charged with capital crimes, those who are convicted, and those who are actually executed?
Yes, sir. The Death Penalty Information Center, which is a nonpartisan think tank that does not take a position on the death penalties, most recent study, which came out in 2020, I think just at the end of the year, established that there is a disparity both from the charging decision all the way to the decision of who jurors decide to impose the death sentence on and who is actually executed. The race of the victim is the #1 factor that will predict who's actually executed. 80% of the people who've actually been executed in the country, their victims were white. In Tennessee, that number is actually 95% of the victims have been white.
And when you look at the current death row, the current inmates on death row, I'm out of Shelby County. Should I be concerned?
Absolutely. Basically, the citizens of the state of Tennessee are paying for the political will of just a couple of prosecutors in this country. Shelby County has, or in this count in the state, Shelby County accounts for more than half of Tennessee's death row. That's why I represent all of these folks. The Tennessee citizenry actually has not been imposing death sentences. We've only had 1 or 2 new death sentences in the past decade. And since 2007, 8 of the 9 death sentences have been people of color. And almost every single new death sentence this century has come out of Shelby County. It is the driving factor for death sentences in this state. And of those numbers, there's a highly disproportionate number of the Shelby County defendants who are people of color.
I thank you for your work, and I want to make sure that we get on the record again that there's a select population on death row that will have a finite period of time if they have not in the past had adjudication of their intellectual disability claim on its merits. If that's the case, they are not going to be able to take advantage of this statute if passed. Is that correct?
That is correct, sir, and they will get no love in federal court either. If they don't take advantage of this 1-year period of time, the federal court doors will be shut. This will solve a problem that has been plaguing the federal courts as well as the state courts and move these cases much faster.
So would it be fair to say that there's several things that we're doing here that will yield a less clumsy, a less burdensome, a less unwieldy system of appeals?
Yes, sir. And I would also say this is not going to open any floodgates. I'm too busy. I represent all these guys. And this isn't going to be the State Post-Conviction Defender's Office doing it. This is going to be my office. And I'm too busy. I'm not going to be filing claims that aren't going to go anywhere because I don't have time and I don't have the money to do it. So this is just going to address a problem that exists. It's going to address a small number of people, and then it will protect the citizenry and the victims and the defendants moving forward for any new cases that are brought.
Thank you. And Mr. Chairman, I yield back.
Thank you, Representative Griffey.
Thank you, Mr. Chairman, and thank you, Ms. Henry, for being here. And I appreciate your passion for your client and your zealousness, and I applaud you for that. I just want to clarify something because from your presentation, it sounds like that Mr. Payne has had no opportunity to ever raise the issue of his intellectual disability in any of his proceedings to date. Is that?
He has filed claims, but he has had the courtroom door shut every single time because the court said there's not a procedure.
Well, didn't the Supreme Court in his 2016 appeal indicate, we concluded that a defendant who had been sentenced to death prior to the effective date of the intellectual disability statute could move to reopen a previously filed post-conviction petition on the basis of the new and retroactive constitutional ruling that we issued in the Van Tran decision? Do you recall the Supreme Court? Is that part of the decision?
Absolutely, but Mr. Payne could not have. I mean, he could have physically filed it. He could have written a piece of paper and filed it. I'm not saying he couldn't. 2 things. One, he wasn't under sentence of death. He'd gotten penalty phase relief. But second, our statute didn't cover him because it was unconstitutional. So yes, he could have filed a futile document, but it wouldn't have gotten him anywhere because our statute did not meet constitutional muster at that time, which is why the court in that case said, we urge the legislature, in Purvis Payne's case, they urged you all to adopt this legislation which is before you today.
Well, I appreciate that, and these cases are extremely complex, and I just quickly read the opinion, so I don't know all the facts and history of Mr. Payne's case. I quickly read the Supreme Court decision. It appeared to me that they were saying there was an opportunity for him to raise it, and it appeared that he did not for whatever reason. I don't know if he had counsel at that point or if there were other circumstances. What I am concerned about, I think you may agree with me that folks that advocate against the death penalty use any and all means to try to keep people from being put to death based upon a criminal sentence that is imposed by a jury in Tennessee. So, and every time there's a new case, it seems like the ball kind of gets moved a little bit, and we all have to adjust based on what the Sixth Circuit does, the Supreme Court, Tennessee Supreme Court. So it seems like it's a never ongoing legal battle that never ends. So I have sympathy for Mr. Payne's situation, but I also have to have sympathy for the victims who were both two murders in this case. So.
Certainly. And so you're from Paris, Tennessee, so you remember the Robert Coe case. And I was very familiar with, and I get those arguments all the time. Oh, you're just against the death penalty. You're just going to try and pull out any trick you can. So I hired the expert that the prosecution used in the Robert Coe case to evaluate purpose pain for exactly that reason. We don't just file any old thing. We do what we need to do to represent our clients.
And then you got one under 70 on Purvis Payne's case, and you got two results, 72 and then 74, I think, wasn't it, on the intellectual disability IQ score?
What the expert says that the prosecution relied on is that every single score, when properly reviewed under clinical standards, is 70 or below. So the reported number is the problem, and focusing on the reported number is how Tennessee gets into trouble, which is why we are the only state in the country who's never granted relief under Atkins.
And now we have a new standard, and it's a broader standard, so we're going to open it up for additional experts to come in and testify again and give their opinion.
Well, I mean, because that's what the U.S. Supreme Court requires, and I think what's great about this particular statute, there was another version of it that was being bandied about that used the phrase current, and that got taken out of it for exactly that reason, so that this is the only bite at the apple that these guys are going to get. If the word current stayed in it, I honestly was telling folks, don't use current, because then I could keep coming back. This statute is going to be one time under the law as the U.S. Supreme Court requires it.
I hope you're right. Thank you. Thank you.
Any other questions for our guest? I do have a question, if you will indulge me for a moment.
Please, sir.
You stated earlier, you said that if this bill does not pass, this particular bill, that there would be continuous litigation going forward. There is other legislation out there, and I've been trying to do some compare and contrast to the two. In comparison to this amendment that we just adopted earlier, sets a 1-year effective date, 1 year within this act, whereas that other does not have that time constraint on there. Are you familiar with this other? I recognized you as being in the room on that day, and so I'm just curious if you can speak to that.
I've been trying to get a copy of the amendment on House Bill 1062. I have not been able to see what the current state of that amendment is, so I don't know if it has the 1 year. I do know that, having worked with Representative Hardaway, that the 1 year was important to the DA's conference and to the Attorney General's office.
Representative Hardaway.
Thank you, Mr. Chairman, and the answer is yes. Our language was adopted for 1062.
Okay, we're already out of session, so we're gonna hear from legal services to give us an explanation to our question there.
Michelle Fogarty, Legal Services. So you're asking me to explain the difference between the amendment we just adopted and the amendment adopted in House Bill 1062. Is that correct?
Yes, please.
House Bill 1062, the House Criminal Full Committee today adopted Amendment Draft Code 6596, which in Section 1 redefines intellectual disability. And in Section 2, it adds a new subsection G, which states that a defendant who has been sentenced to the death penalty prior to the effective date of this act and whose conviction is final on direct review may petition the trial court for a determination of whether the defendant is intellectually disabled. The motion must set forth a colorable claim that the defendant is ineligible for the death penalty due to intellectual disability. Either party may appeal the trial court's decision in accordance with Rule 3 of the Tennessee Rules of Appellate Procedure. And then it adds a subdivision G2, which states a defendant shall not file a motion under subdivision G1 if the issue of whether the defendant has an intellectual disability has been previously adjudicated on the merits. In this committee, as to House Bill 1, the committee just added an amendment with draft code 6117. This amendment in Section 1 adds a new subsection G, just like House Bill 1062, but the language in that subsection G states, a defendant who has been sentenced to the death penalty prior to the effective date of this act and whose conviction is final on direct review may, within 1 year of the effective date of this act, petition the trial court in the county of conviction for a determination of whether the defendant is intellectually disabled. The petition must set forth a colorable claim that the defendant is ineligible for the death penalty due to intellectual disability. If the trial court determines that the petition sets forth a colorable claim, then the court shall order a hearing at which the state and the defendant may present witnesses and evidence. At the conclusion of the hearing, the court shall issue written findings of fact and conclusions of law. Either party may appeal the trial court's decision in accordance with Rule 3 of the Tennessee Rules of Appellate Procedure. And it also adds a subdivision G2, which is consistent with House Bill 1062 amendment that we adopted. So the different language is within 1 year of the effective date of this act, and the trial court shall order a hearing at which the state and the defendant may present witnesses and evidence, and then the court shall issue written findings of fact and conclusions of law.
Thank you. You have any questions for legal representative?
No, sir, other than we achieved the same goals.
I can tell you that the language is different in both. I can only tell you what's on the paper, and it's that the language is not identical.
All right. Thank you, Mr. Chairman.
Yes, sir. Thank you. Any other questions? Representative Griffey.
Thank you, Mr. Chairman. Ms. Henry, let me ask you, have listened to the difference, and I don't know, I don't want to, you haven't really had an opportunity to sit down and maybe study both bills, but it sounds like the bill that Representative Hardaway is proposing would have a 1 year period that people must file within that 1 year period, or they are going to waive that claim. Does that seem, it seems like that's probably, this version is maybe a little more restrictive than the other version from the other bill that was discussed. Would you agree with that assessment?
I would agree with that. I think that was the intent of putting the 1 year in, was to provide some assurance of finality to this committee that this would be 1 year and then be done. That was part of the goal of moving the cases quicker.
And not necessarily the hearing, but you have 1 year to file your petition.
Right. So you can't just sit on your rights.
Right. Thank you. Thank you, Richard.
Leader Lamberth.
Thank you, ma'am. We probably disagree on just about everything in life, but I want to say this. I really appreciate the job you do. So you have an extraordinarily difficult job. If we're going to execute someone, I want to make sure that, every opportunity has been taken, whether we pass this bill or not. I mean, there are a lot of procedures out there to make sure that those that are being executed are guilty of the offense that they've been found guilty of, and that the proper procedures through the court system were taken to ensure that the worst situation will not occur and that an innocent person be executed. And so I appreciate the job you do. Thank you for it. I cannot imagine, and most of us cannot imagine, how extremely difficult it is on you, and quite frankly, on the attorneys in the Attorney General's office that many times you're against, to handle these type of cases. They're all heartbreaking, and everybody loses because of the heinous nature of these crimes. And so I just want to say I appreciate the job that you do. It's extremely difficult. Thank you.
Thank you.
Thank you, Representative Griffey.
Thank you, Mr. Chairman. Briefly, Ms. Henry, I want to pay you the best compliment I can, and that's Mr. Payne is fortunate to have an attorney of your caliber represent him. So thank you very much for what you do.
Thank you.
Thank you. Any other questions for our guest? All right. I want to say thank you very much. You and I have met before on this issue and discussed this, and you've been very diligent in coming to our meetings that we've had and working with Representative Hardaway. So thank you very much for your efforts in this endeavor.
I appreciate the time. Thank you.
Yes, ma'am. Okay, members, we are going to go back into session. We are back in session. Representative Curcio, you're recognized.
Thank you, Mr. Chairman. I move previous question.
Previous question has been called. Any objection? Representative Hardaway.
Thank you, Mr. Chairman, and I had conversation with the members that I wanted to make sure that we got the testimony of the witnesses on the record, but that I would not move the bill today without a commitment that should the bill be moved to full committee, that it would be held there while 1062 proceeds. But Black Caucus became interested in this in the interest of justice, looking at the fact that there are disparities which exist in the system. That's undeniable. The data is real. No one disputes the data, but disparities exist. You also have heard the testimony that those who are intellectually disabled are more at risk because of the deficiencies in Tennessee state law, current TCA. You've heard testimony of the unconstitutionality of executing the intellectually disabled. So Black Caucus has seen all of these issues and has taken it upon themselves to make sure that we filed the very first piece of legislation for the 112th General Assembly to address this issue. But, Mr. Chairman, we have another bill, 1062, that I'm also signed on to, but this is a matter of life and death. We're not going to get a chance to start back over without putting at risk some of the individuals who need to be heard, need to get into court to present their claim for intellectual disability. So my commitment to the members, and I've spoken to most of you, is that if you will move the bill to full committee, that we will hold it there while 1062 progresses. Thank you, Mr. Chairman. Thank you, committee members, in advance.
Okay. Thank you for that. The posture that we're in was an objection to previous question. So we are now going to be voting on previous question. All those in favor of previous question say aye. Aye. Those opposed, no. The ayes prevail. We are now voting on sending House Bill 1 on to full criminal. All those in favor say aye. Aye. Those opposed, no. No. The noes prevail. The bill fails. Next item on the calendar, item number 3, House Bill 1143 by Vice Chairman Grills. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman and committee, and good evening to the rest of you. This bill seeks to add more teeth into the law to drivers who are caught repeatedly on revoked and suspended license. Currently, the first offense is a Class B misdemeanor, and the second subsequent offenses are Class A misdemeanors. And this bill changes the third and subsequent offenses after that to Class E felonies. Ultimately, we just want to increase the penalty, try to hopefully deter repeat offenders. This bill was actually, I think about 2-3 weeks ago, we actually brought it up and had a little bit of discussion about it. And we had a few people that had some concerns, and we went back and forth and talked about those. I don't know that any of those concerns are necessarily have been remedied, but I want to move forward if there's any way possible, Mr. Chairman.
Okay, thank you for your comments, explanation. Any questions for the sponsor, Representative Beck?
Thank you, Representative Grill. I have gone backwards and forwards on this. I have a lot of concerns that it's too harsh, and then I go back to driving's a privilege. I don't know. But anyway, I just want to tell you that I have a lot of concerns where this is going. Thank you.
Thank you. Leader Lamberth.
So I feel kind of compelled to speak on this. I mean, I carried the bill a couple of years ago that did away with habitual traffic offender or habitual motor vehicle offender, and it left a bit of a gap in the statute for those that are just flagrantly disregard the fact that their license has been revoked. So this is a much cleaner way to accomplish that. If you have someone that just over and over and over again gets out there and disregards the fact that they've lost their license for a variety of reasons. I will say I hope that the court system will always work with someone if they're in court on a driver revoked license to figure out why it's revoked and help them get their license back. That's the courts that I practice in, and I don't know about the other attorneys on the committee, but the courts that I practice in, that's always the first question a judge asks someone if they're in there on a driver revoked license case is, hey, can you get your license back? And that's the goal in every case, is to hopefully get someone back to a fully licensed legal status.
Thank you. Next on my list is Representative Russell.
Thank you, Mr. Chairman. Would this bill put the driver in the same offense as a habitual motor offender?
I can't answer that there, Chairman Russell.
Would you like to go out of legal to get explanation?
Yes, please.
Okay. We'll go out of session to hear from legal.
It's Michelle Fogarty, Legal Services. It's my understanding that actual statute was repealed in 2019, but at the time it was a Class E felony. Does that answer your question?
So there's no more habitual motor offender statute?
I don't believe so.
Thank you. That's all I got.
Well, let me see.
Any other questions for legal?
Oh, are you waiting?
Okay, no, we're fine. Okay, members, we'll go back into session. Representative Russell.
Thank you, Mr. Chairman. I got my questions answered.
Very good. Chairman Curcio.
Thank you, Mr. Chairman, and thank you, sponsor. I understand the intent of the legislation. I just want you to understand where I am today. I know we've talked about this before, but our good friend Judge Carter in Civil Justice Committee earlier this year told a story about a man that he referred to as Tiny. I don't know if that's his legal name or not, but that's the way he referred to him, and told a very impassioned story about how he went to revoke this man's license simply because he couldn't pay the fines and the fees. And he told a very impassioned story about how that man needed to feed his children, needed to work to feed his family. And so this is an issue that I know I've worked with Judge Carter on before. And unfortunately, I think this bill paints too broad of a brush for me. If we were to limit it to certain offenses or something like that, but unfortunately, this will pull in folks who just simply cannot afford to pay the fine and the fee. And so those are my concerns, and I know you and I have talked about that previously, and I just wanted to make sure that I got that on the record, that I completely and wholeheartedly understand your intent. I just do think it's overly broad as drafted. So thank you for bringing the bill.
Thank you, Mr. Chairman, and Chairman Curcio as well. Over here in the code 55-50-504, subsection A, it gives which is referred to in the bill. It talks about the canceled, suspended, or revoked because of a conviction of vehicular assault, vehicular homicide, or driving while intoxicated shall be punished. So it's my understanding that there's three conditions there that can be, you can lose the license or have those revoked. Does that give any more clarity? I believe it's a little more narrow than maybe you were originally thinking it was.
You want to respond?
No, sir, I'm good. I think I'm reading the bill correctly, but.
Any other questions? Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1143 on to full criminal. All those in favor say aye. Those opposed, no. The ayes prevail. You move on to full criminal.
Thank you, Chairman. Committee, y'all have a good night.
Item number 4, House Bill 221 by Representative Chisholm. You have a motion and a second. You are recognized.
Thank you, Chair and Committee. I thank you for your indulgence. Today, as we talk about House Bill 221. And what House Bill 221 does, it requires a court to grant judicial diversion for possession of less than an ounce of marijuana, regardless of the defendant's prior criminal convictions. So in 2018, there were 1,307 opioid overdose deaths reported in Tennessee. 0 of those were related to marijuana. And I'm talking about all this to let everyone know about how marijuana is not one of those drugs that harm as many others do. The main drug that caused 45% of deaths in Tennessee was fentanyl, not marijuana. And also, according to the Very Institute of Justice, in 2016, Tennessee made 8,714 arrests from possession and another 2,506 for sales arrests, which totaled 21,000 arrests for marijuana. The average cost of an inmate being $23,468, which brought the state grand total to upward of $561 million. We spend a lot of money incarcerating for a plant that's legal in 16 states. Also, you have states like Mississippi that passed medical marijuana with 68% of the vote. So I bring this bill here today, and I also look forward to working with members of this body, our law enforcement, our DAs, and all other stakeholders over the summer and over another period of time. With that, I'll take any questions before we make our next move.
Thank you very much. Any questions for our sponsor, Representative Beck?
Thank you, sponsor. And, okay, straighten this out for me. This bill is not decriminalizing, but will allow for judicial diversion. Is that correct?
That's correct. Yeah, this bill does not legalize. This bill does not open up the floodgates. What this bill does, it offers diversion instead of jail time.
Representative Beck?
Thank you. And I just think that's a brilliant way to head this in this direction, because it will still bring some accountability to people who go forward, but except we're not going to I noticed in the fiscal note, it'll save yearly over $2 million to locals, and for victimless crime, basically. And I really appreciate you bringing this, and I look forward to supporting it.
Thank you. Leader Lamberth.
Thank you, Mr. Chairman. And while my colleague from Davidson County has articulated this is an interesting way to go about, in essence, legalizing marijuana, it doesn't do that, but it would allow for unlimited diversions, which we've never done in any crime in the history of Tennessee. It is worthy of discussion, and I think that at this point, the best probably posture for this bill would be I would make a motion to send this to a summer study.
There's a motion for summer study. It has been seconded. Any objection? Seeing none, we're now voting to send House Bill 221 on to summer study. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. House Bill 221 goes to summer study.
Thank you, Chairman. Thank you, committee.
Thank you. Take a stroll down through our calendar to item number 10. House Bill 1183 by Chairman Curcio.
Thank you, Mr. Chairman.
You have a motion
Second.
and a second. There you go. You're recognized.
Thank you, Mr. Chairman, and thank you, committee. I do have an amendment on this bill. It is coded 6744, which I wish to move now.
You're recognized. Motion second on that amendment.
Thank you very much. Members, this bill as amended was brought to me by one of my public defenders. His name is Travis Jones down in Murray County. I know General Cooper, who's with us here in the building today, knows him. And it seeks to clean up a process that is really already current law. When a judge sentences someone to probation for more than one offense, the judge sentences the defendant to either concurrent or consecutive probation sentences. Concurrent sentences are intended to be served at the same time, while consecutive sentences must be served one after the other. If an offender's probation is revoked and the two sentences are to be served in the same jurisdiction, the process is relatively straightforward. The offender either serves a sentence at the same time or back to back. Unfortunately, for offenders with probation sentences in multiple jurisdictions, the separate sentences do not officially begin until each judge revokes probation. This glitch in the system leads to enormous losses of both time and money spent transferring offenders from jurisdiction to jurisdiction in order for their sentences to be officially revoked. For concurrent sentences, these transfers and delays in the judicial process mean that an offender could end up serving more time than their sentence authorized. For consecutive sentences, this issue does not always create such an extension because the officer must still be transferred to the new jurisdiction to serve out the remainder of their sentence. House Bill 1183, as amended, seeks to patch this glitch by crediting any time served on probation revocation towards any other concurrent probation sentence that is subsequently revoked in any other jurisdiction. The intent of this legislation is to make concurrent sentences truly what they are meant to be, concurrent. With that explanation, I'd take any questions on the amendment.
Thank you for that explanation. Any questions for the sponsor on this amendment? Motion has been called, or question, okay. Are you out of service tonight too? Question has been called on the amendment. Any objection? Seeing none, we're now voting to adopt amendment number 6744 on the House Bill 1183. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. You adopt. We're on House Bill 1183 as amended. Question has been called. Any objection? Seeing none, we're now voting to send House Bill 1183 on to full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman. Thank you, committee.
Next item on the calendar, number 11, House Bill 1449 by Chairman Curcio. You have a motion and a second. You recognize.
Thank you, Mr. Chairman. I actually wanted to roll this bill 1 week, if possible.
Okay.
Yep. Last calendar would be perfect.
That'll
Thank
be
you very
great.
much.
Without objection, roll to the last calendar.
Thank you, Chairman. Thank you, committee.
Item number 12, House Bill 1121 by Chairman Farmer.
Yeah, thank you, Mr. Chairman and committee, and this bill does exactly what it says it does. It just creates a Class A misdemeanor for any person to attempt to access or obtain confidential information from the department concerning reports of child sexual abuse or neglect if the person knows it's a violation of the law.
All right, thank you. There's an amendment coded
Yes.
4550. Is that,
Motion on amendment.
you wish to proceed with that?
I'm sorry, Mr. Chairman, members, I've got so excited I got ahead of myself. There's an amendment, drafted code 4550.
That is correct. You have a motion and a second on that amendment.
Thank you.
A question's been called on the amendment. Any objection? Seeing none, we're now voting to add amendment number 4550 on the House Bill 1121. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. We adopt. We are now on House Bill 1121 as amended. Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1121 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. Item number 1319, by Representative Hardaway. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. You kind of caught me off guard here.
I apologize for that. There is an amendment with this, traveling coded 6721, if that's one that you would entertain.
Yes, sir.
You all right? You're recognized on the amendment.
Thank you, Mr. Chairman. That amendment rewrites the bill, and it requires the judges, if practicable, to notify the individual at that time of sentencing of what their prospects are for expunction.
Question has been called on the amendment. Any objection? Seeing none, we're now voting on adding amendment number 6721 on the House Bill 1319. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You adopt. We're on House Bill 1319.
Renew my motion, sir.
Okay. We're on House Bill 1319 as amended. Representative Griffey has, you recognized.
Thank you, Mr. Chairman. Thank you for sponsoring bringing legislation. Let me ask you this. Would the notice be satisfied if the judge or the court personnel simply handed a card to anybody that's convicted of a misdemeanor? Here's a list of the expungable offenses, and this is what you got to do. Would that satisfy the notice?
Representative Harway.
Thank you, Mr. Chairman. And thank you for the question. Actually, the procedure, I'm leaving up to AOC and the courts.
Any other follow-up, Representative Griffey?
Well, then, what you've indicated to me that unless they take steps to prohibit that procedure, it seems like handing a card to the defendant saying, hey, if you're convicted of any of these offenses, you are eligible for expungement, and that would satisfy the intent and the notice of this bill. Is that something, would you disagree with that?
Not being an expert as you are, sir, and having spoken to AOC and different judges, I'd rather leave that up to AOC and the judges.
No further questions. Thank you.
Thank you. Any other questions? Representative Russell.
Thank you, Mr. Chairman. And sponsor, does this bill require judicial diversion regardless of how many times they are convicted?
Thank you for the question, sir, but that's not what this bill addresses.
Thank you.
Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1319 to full criminal as amended. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. Item 14, House Bill 1320. Representative Hardaway, you are recognized.
Thank you, Mr. Chairman. And one of the more heinous crimes to me is forcing children especially to participate in criminal gang activity. And the goal of House Bill 1320 is to deter such recruitment by increasing the penalties. With that, I'll ask for a favorable vote.
Thank you for your explanation. Previous question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1320 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. Item 15, House Bill 1321 by Representative Hardaway.
Second.
You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. I actually have an amendment that's designed to keep this bill from conflicting with a bill that passed earlier dealing with road rage.
Representative, it would be untimely. Would you care to roll it to the final calendar so we can get that in the proper posture
Yes, sir.
that time? Okay. Without objection, we will roll this to our final calendar. Item 16, House Bill 1323 by Representative Hardaway.
Motion. Second.
You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. The objective for House Bill 1323 is to make sure that when we have victims of domestic violence, especially, that they know what their options are in terms of showing up at the hearing for bail and the other options that are available that we've already got in statute. This would just give them that information in a written form so that they can take advantage of their rights.
Thank you. Would you mind withdrawing that motion? Thank you. I did have a question for the sponsor on this, unless there's anyone else that had a question before that. But Representative Hardaway, my question to you is this: what if in a county that they do not use the GPS monitoring systems, would this cause someone who has made bail for that charge of domestic violence to have to sit in jail waiting on a service provider from another county or somewhere across the state to come in to attach this monitor if the magistrate granted this, or what's the procedure for that?
Thank you for the question, Mr. Chairman. This doesn't address the actual implementation of the GPS monitoring system. Just notice to the victim at the time, the location of the incident itself, in a form that they can maintain, written form, and be able to review it later. It in no way forces any of the counties, the law enforcement agencies, to do anything different other than what they're doing right now in terms of GPS monitoring devices.
Okay, thank you. So this would be a uniform form that would go across the state. Is that correct?
Yes, sir.
Okay. And so if that county does not use the GPS program, then that section of the form would be null and void in that instance.
Yes, sir. It would reflect that on the form.
Very good. Thank you very much. Any other questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're now voting to send House Bill 1323 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on. Members, that, believe it or not, we've completed our calendar. And so, any other business before we dismiss for the evening? Seeing none, we will stand adjourned. Yeah. We're adjourned. Thank you.